So let us talk about separation of powers. Okay, so of course, I think in previous discussions we have discussed already the concept of separation of powers in relation to the form of Philippine government. Okay, so under our system we have this unitary presidential type of system. Okay, so what do we mean by being there in this kind of system? So it would mean that of course we are in a of course I think it's understood that we are in a democratic and republican state. That I think that's the no, that's the presumption. But the question is, what would be now the structure? What would be the structure and the eventual powers from that structure of government? So general the general premise of our structure of government rests upon this concept of separation of powers. Okay, so when we speak of separation of powers, there are three branches of the government. So under our constitution, we have Article 6, Article 7, Article 8 of the 1987 Constitution. So Article 6 refers to the legislative department or Congress. Article 7 refers to the executive department, which generally speaks about the president and its related offices under his wing. Okay, then the Article 8 would refer to the judiciary or the Supreme Court. Okay, so what is this nature of separation of power? So remember that although these are three branches of government, when we speak of three branches of government, each office, the legislative, the executive, and the judiciary, has their own powers as vested by the Constitution. You can see that as reflected in the first articles of these sections that I just mentioned. So, Article 6, Section 1, all legislative power is vested through Congress. Okay, Article 7, it is vested, the power, the executive power is vested upon the president. Okay. Then Article 8, Section 1, it defines that the Supreme Court shall exercise its judicial power. Okay. So they have these definite powers. But with this concept of separation of powers, I think it is understood that these three branches of government has this independence. So what do we mean by independence of these three branches of government? Simply speaking, when we speak of independence, these departments cannot, at the most, interfere with their affairs. Okay, so if remember that we have this structure, this traditional structure of these three separate branches of government. We know that in the traditional structure, the legislative passes the laws. They are the ones who create the laws or the statutes. Okay, the executive department sees to it that after signing the law, he sees to it that he's going to execute the law. What do we mean by execute? He would be able to faithfully implement or faithfully make do good of what is stated in these laws that was made but that was passed by Congress. Then the judiciary will always be there as a with the general idea that the judiciary would have these checks and balance between and among these three branches of government. So whether or not the legislative may have acted in grave abuse of discretion amounting in lack or excess of jurisdiction, or there are certain acts which Congress or the executive department would have done which is not allowed, or it is absent within the confines of the Constitution, the Supreme Court would be able to check that kind of power if it is that in excess of the powers that are given to them by the Constitution. Okay? But of course, despite this fact that we have this independence of the Constitution, these three branches of government usually respects each other with their with their operations, or with their functions. Okay, so aside from independence, it must be noted that the three branches of government has this inter-branch courtesy. Although they have this separation of power, sometimes these three branches of governments tend to give they tend to give each self with each other. It's not really necessarily a matter of favor, but usually it is more of a respect on the institutions. Okay, so it's more on a respect of you wanted to go ahead and try to do something. Okay, actually, if you are into this, in the as I'm speaking, if we are into the Senate hearings, diba? If you can discern it, okay. I think the vice president, if you can see from the news, is she's trying to invoke this concept of inter-branch courtesy. She's not direct about it, okay, but she's trying to invoke that inter-branch courtesy aspect, because, well, she is saying that, well, in the previous budget hearings, there were no questions as to how are they going to there are no questions as to the budget, so it was automatic. And she's also harking it even on previous administrations that the budget is not accepted, is usually automatic, or is just accepted, because there the previous congresses would invoke this interbranch courtesy, but these days she cannot. The Congress is resisting from that. Some are even say that it's a tradition. It's not necessarily a tradition. Well, in a sense, this is just my view. Okay, of course, your interbranch courtesy exists for the sole reason that we have the separation of powers. But you have to also consider the fact that at the end of the day, if there is a need to preserve the independence, as well as to promote the check and balance of the three branches of government, um, some while some would consider that, it's the judiciary who has this power to determine if there's a wrong interpretation or whatnot. Okay, I would think that, of course, Congress, even the executive department, has also this power of exercising its own discretion at times. So, like here, what happened with Congress here is removing all of those political issues, or political motivations of those who are asking the vice president. If you're going to look at it in a sense, you can say that, of course, the legislative department, although there is this concept of interbranch courtesy, they chose to exercise the independence, as well as they also chose to implement checks and balances. So in this situation, they are trying to scrutinize the budget of the office of the vice president in previous years before they're going to give their budget for next year. Are they right in doing so? Actually, there's not yet an actual case, if you're going to ask me. But they seem to be exercising it as a matter of check and balance, because, of course, they wanted to release they are trying they're trying to assess what budget is to be given un, under the upcoming General Appropriations Act for next year. So they have to they have to know that what really happened to those funds. Okay. Now, of course, the vice president can always say that they have to she has to go to this process under auditing, like in COA, diba? You need to answer all those notice of these allowances at the proper venue, which, well, she is alleging that the congressmen are now using. Okay, but nonetheless, this is something that has not yet been touched, because, well, documents can be always be used in those investigations. Okay, but just to go back to this point. Okay, so while these three branches of government are independent, of course, they have this capability of course, they can invoke the interbranch courtesy, as well as they can invoke the checks and balance. Now, it would depend on the situation. If the situation does not really have questionable or doubtful particulars, of course, sometimes it is the discretion of a branch to declare to just accept it as a matter of interbranch courtesy. Otherwise, they can also exercise their checks and balance. Okay. All right. So, what would be the limitation of this separation of power? So, of course, I think we already have this discussion on political questions. So, what is this? What are political questions? So, as far as we understand, even before the concept of judicial review, political questions are questions of a branch of government in which courts cannot interfere or cannot take cognizance of such questions or challenges before the court, because the court would deem it that it cannot be justiciable. Why it's not going to be justiciable? Because more or less that political question is an act which originates with the wisdom of that branch in implementing such act, diba? So when we speak of political questions, it refers to the wisdom of the actor. So it has been held that if the question is that of a political question, courts cannot interfere, or courts cannot make a decision, because these are matters which are led to either the wisdom, or sometimes it's the exercise of the discretion of the people as a particular. Okay. So, of course, the idea here is the initial idea of your political questions is, of course, for for the judiciary not to interfere or hamper any acts of the executive or the legislative if it is within their realm. Okay, so for example, one good example of a political question, which of course it's not yet clear, because remember that there is a I don't know what happened already as I'm speaking right now. I don't know what happened to the case filed by former Congressman Tevez. Remember that former Congressman Teves was expelled from Congress, okay, for certain issues, like he's not already attending Congress. Then of course he has this pending case, which is he's now right now in East Timor, okay. But I think before he left, or I think when he already left, he has a petition pending with the Supreme Court questioning his expulsion, okay. But right now, of course, the traditional construct, or the traditional jurisprudence that is currently available with respect to this would be Alejandrino versus Quezon and Osmeña versus Pendatun. So this refers to the discipline of members of Congress. So in those cases, it was ruled that the discipline of members of House of Congress remains in this wisdom and discretion of the legislative department. Being so, the courts cannot interfere with the acts done by Congress with respect to their institutional powers. Then one of those institutional powers is the power to discipline their members for certain violations within the rules of Congress, be it in the Senate or the House of Representatives. Okay, so we have this concept of political question. Now, I think we had the discussion on political question insofar as judicial power is concerned. If you can recall, of course, if you can recall the case of Francisco versus House of Representatives, it was mentioned there that the judicial review was kind of expanded. The definition was expanded in the 1987 Constitution because it is designed to prevent the executive from usually citing the political question doctrine. Okay, so of course the question now is there still a political question? Does the political question doctrine exist? So note that if you're going to read Article 8, Section 1, it would appear that the political question doctrine seems to have been abrogated. But however, after the 1987 Constitution, there are certain decisions which would in which Congress would not, I mean not Congress, the Supreme Court would not touch the Supreme Court will not touch the wisdom of such branch of government, be it Congress or the executive department, on matters because they would say that this is within the wisdom of the no this is within the wisdom of the said department. Okay, so although usually these days, if you would observe your cases before the Supreme Court, what the Supreme Court does is they would always make the case unless if there are technical issues, because as we know the Supreme Court is always would always find ways to dismiss the case based on technicality, and I think that's a good thing because the Supreme Court cannot just be clogged with lots of petitions directly which are directly filed to them. Okay, so putting aside all those technicalities, let's assume that there is a public paramount interest or there's a transcendental importance over such case. They usually they would usually approve it for judicial review. However, what the Supreme Court will do is, although they would approve it for judicial review, they would they would usually determine the case based on the merits. Okay, so if the merits itself would warrant or would not warrant a favorable unfavorable decision to the government, they are going to apply the law. They would not resort to attacking it as much as possible with respect to judicial review, unless there would be a glaring procedural lapse or a procedural wanting with respect to the requisites of judicial review. So if there is a need for a determination based on paramount public interest, the Supreme Court usually does accept it for judicial review, but sometimes they would try to scrutinize it based on what was given as a merits or what would be the standing of such question resolution or law. Okay, so then we have this concept of legislative veto. Okay, so legislative veto, this would be this is primarily discussed in part and parcel of this concept of oversight powers of Congress. So legislative veto as a practice is considered as unconstitutional. Previously, this was an American US United States Supreme Court concept under the case of this case of INS versus Chadha. Okay, so if you can recall INS versus Chadha, there is this law which an immigrant may still be rejected by Congress. Okay, so the applicant that applied from that applied visas or citizenship with the INS. This is the, I think, internal and the nationalization service of the United States. This is equivalent to your Bureau of Immigration here. So when you apply to the INS, usually there was this provision that prior to the approval of the INS, you still have to go through Congress. The Congress may still veto that application or that relief being sought for by an alien or a sit or the one who wants to migrate in the United States. The Supreme Court of the United States stated that the pertinent provision allowing for Congress to interfere on the applications is tantamount to a legislative veto, which is not allowed because it's going to be a violation of separation of powers. Okay. Of course, this was applied in cases here. So we have this case of Abacada Guro party list versus Purisima, where was a question on the attrition law. Okay, so the Supreme Court held there that the oversight provisions, if you would observe most of your if you would observe most of your laws, okay, would have these oversight provisions under the near end of your the public acts, okay. So of course the purpose of your oversight provisions of your oversight is, of course, this is part and parcel of oversight. So oversight may partake into different forms. So one example of oversight is what's happening right now in Congress. So they're exercising their oversight power if they are doing inquiries in aid of legislation. Now, in within the framework of the statute or a Republic Act, you would see an oversight function clause there near at the end of such statutes or Republic Acts. Okay, that the case of Abacada Guro versus Purisima ruled that that oversight portion should be worded in accordance to should be worded or should take into consideration the concept of separation powers. It was held in that case that the particular oversight clause, as indicated in the Attrition Law or the Attrition Act, would give unbridled authority to Congress to interfere with the work of the Bureau of Customs. Okay. That being said, it is considered a legislative veto, which would be unconstitutional because it would transgress into this separation of powers that is being enjoyed by the three branches of government. Then finally, we have this, and this is a little bit new because this was mentioned in Pangilinan versus Cayetano in particular. So we have the Youngstown framework. Okay, so the Youngstown framework is a framework which is American in origin. So this was first first implemented by this was first conceptualized in the steel seizures case in the United States by the United States Supreme Court. So the Youngstown framework, actually, it's not really within that decision. This is a framework that was created by Justice Robert H. Jackson as part of his concurring opinion in the said Youngstown case. So what's the premise of your Youngstown framework? So the Youngstown framework is more on the interaction between the executive and the legislative branches of government, because there are some areas of concern with respect to the implementation of certain acts in which Congress and the executive department has these shared powers. Okay, it's either shared powers or there's an interaction. So Justice Robert Jackson kind of lumped it into three areas or three prongs. So if the department, let's say the executive department or the legislative department, can act on those powers on its own, well, there's no problem with it. Okay, so because that's part of their powers. Okay, if there's non-interference, that's okay. Then the second prong or the second layer would envision where there are powers, but there is a gray area. Of course, the exercise may have a gray area. Okay, if that is the case, if there is a gray area, if in as much as if the executive and the legislative department can find a way to implement it without resorting to constitutional controversy, they may do so. They may fill in the gaps. They may try to reconcile provisions of the law, or reconcile on how are they going to exercise their power. Okay. Of course, the third prong is the extreme one. It means that, but if there is if the power itself, there is a need for that there's a need for Congress to interfere, or Congress needs to has a say over such power. It can do so if such power needs their ratification or their approval, because there would be a situation where sometimes the executive department may exercise grave abuse of discretion. And in order for Congress to be able to check it, even before it goes up to the courts, Congress can reject or can question that authority. Okay, so that's the essence of the Youngstown framework. Actually, they would, if it's going, remember that the case of Pangilinan versus Cayetano was dismissed because it was already considered moot and academic, because, well, the ICC already withdrawn, the ICC accepted the withdrawal of the Philippines from the Rome Statute. The Supreme Court just crafted this by way of their symbolic function. They decided Pangilinan versus Cayetano on the premise of its symbolic function of trying to provide guidelines for the bench and bar for future cases like this. So now, whether or not the Supreme Court in the future would be confronted with a similar case like Pangilinan versus Cayetano, it's we have already the Youngstown framework. Of course, this is also without prejudice to the Supreme Court establishing another set of guidelines. Okay, but of course, we need to have, as we have discussed previously in judicial review, this concept, there should have been an actual case with respect to the separation of powers. Okay, all right. So